I'm so excited to introduce our speaker for this session, Professor Sarah Orr. Sarah is a clinical professor and director of the University of Wisconsin Law School's Consumer Law Clinic, where her focus centers around increasing access to debt justice. Thank you, Sarah, for joining us today and sharing your expertise on consumer rights. With that, I'll turn it over to you.
Thank you so much to Lawyers for Learners for inviting me to participate in this series. I have been working with law students and consumers at the Consumer Law Clinic since 2008. And from that experience, I believe that consumer debt challenges come from, first, the consumer debt itself, and second, the legal system's handling and treatment of consumer debt. To start, I'd like to share with you a painting, and which is on the next slide, please. So the title of this painting is Kitchen Table Economics, When There Are More Bills Than Money. So when I have asked my law students to share what comes to their mind when they look at this painting, they share sadness, reality. They also say that it gives them a sense of isolation, feelings of shame or embarrassment, pressure, fear about the future, and a sense of being frozen or unable to take action. So this is what I meant by the fact of consumer debt, expressed in a piece of art. You may see yourself in this painting. You may see someone you know in this painting. And so the painting conveys a sense of individuality, but also something universal, something we can all relate to. Next slide, please. So if the green light shining on our friend were my voice, I would say first, you are not alone. We are all consumers in an economy that is designed to put us in debt. I also would say that being in debt does not make you a bad or immoral person. If you can't pay, you can't pay. Now, debt collectors or creditors want you to pay them first and might want you to make decisions that are not the best decisions financially for you or your families. But I really want to emphasize that if you can't pay it, you can't pay it. And you need to make decisions that are best for you and your families, and the choices that are going to keep you going financially and not cave into pressures from debt collectors or creditors. And third, I would say take a step to help yourself. Read the paperwork. Look for resources. There are quite a few legal resources online. There are also look for free financial wellness resources. Also participate in the legal process. Try to make a payment plan if at all feasible. Just take a step. This can start to reduce that feeling of being frozen or being stuck. It also helps to begin the process of retaking control of a situation that feels very much out of your control. Also, taking a step is important in the legal process. And I think with that, we'll go to the next slide. So what is consumer debt? The papers on the table of our friend in the painting may be from a credit card, an auto loan, a home mortgage, education debt, a payday or installment loan, or a personal loan from a bank or a credit union. Now, these examples involve consumer credit, which then produces debt. And the thing about these is that interest is charged and can really mount up. With the interest mounting up, I have noticed that anxiety in our consumers also increases. Um, Sometimes they have not remembered the debt. It could be from a long time ago. And so the debt has grown significantly because the interest on that debt has accrued. And the final four in this list include debt from medical services, from back rent, from telecommunications, and from utilities. All of these are considered consumer debt. Next slide, please. Our friend in the painting also may be dealing with amounts owed to a local, state, or federal government for state and federal income taxes, local property taxes, government student loans, child support, or unpaid fines and fees. And because these are owed to the government has special methods that it can use to collect those debts. So the first challenge is the fact of the debt. The second challenge is the legal system's way of handling consumer debt. When a debt hasn't been paid, it goes into default. And when that happens, it's very likely that the party to whom the money is owed, or a party will file legal action in court to require payment of that debt. Many of these actions, most in my experience, are filed in the small claims court here in Wisconsin, which handles claims for under $10,000. So in these cases, the party seeking payment is the plaintiff and the consumer is the defendant. Frequently, the plaintiff is not the party the defendant first dealt with. And the plaintiff may have purchased the debt. Many defendants don't respond to the legal action. And it could be because they don't recognize who the plaintiff is. Plaintiffs are represented by lawyers in high volume legal practices. Next slide, please. So here's another painting from the same series that is titled, "A Judge Issues a Stack of Default Judgments in Favor of the Creditor Against the Debtor." And this is true in the Wisconsin courts where we practice. Judges issue default judgments en masse against the consumer, the defendant, and in favor of the plaintiff, because the defendants typically don't respond. And our role, our hope, and our efforts are to increase participation in the court process so that you or your friend or your family member don't end up with a default judgment. You don't want this. That's why I say in the beginning, try to respond to the legal papers and go to any hearings that are scheduled. Many of the hearings are still scheduled by Zoom, and so you may not have to actually physically leave your house or leave your work to go downtown and appear in court. If you don't respond, you lose a chance to tell your side of the story, of the case, and possibly to work out a payment plan if that is feasible for you. So some questions, why might you want to respond to this? What if you've never dealt with the plaintiff before? It could be that they're seeking payment on a very old debt you don't remember. It could be that they purchased the debt and are suing you for the amount claimed. What if the amount claimed is incorrect? These are reasons why you want to participate. I have the sense after practicing in this area for quite a long time that the court commissioners in the small claims court also want people to participate. They don't prefer to stamp these default judgments when nobody on the other side is appearing. They would prefer that people participate in the process. And the small claims court proceedings are quite informal, so you can navigate it without an attorney if necessary. So I want to hopefully decrease fear about involving yourself in the court and legal process, because you aren't required to know the laws of the court, the rules of the court so much. It really is set up for people without attorneys to participate. Okay, next slide, please. Okay, so show up, participate, take a step. And I've provided the information for the Consumer Law Clinic, both the phone number and the online portal, the intake portal. And I believe that the link will be posted and is posted in the webinar at present. That will take you to a series of questions just to let my students know what you're contacting us about, and the students will get back in touch with you as soon as possible. So that kind of concludes the first piece of the presentation. And I think let's go to the next slide. Okay, so many times a legal action on a consumer debt results in a money judgment. Even when a person shows up in court and might have some facts to dispute, many times that results in a judgment being entered. One way for the judgment creditor to collect on that judgment is to get a court order for the debtor, the consumer's wages to be withheld. And that order has to be sent to the person's employer, so the employer is aware that money should be withheld from the paycheck in order to pay on the judgment. So part of the process, an important part of the process, is that the judgment creditor sends a lot of papers to the consumer, to the debtor. And so I harken back to the first piece of art that we looked at, and our friend sitting there at the table may be looking at garnishment papers. Next slide, please. So in the garnishment process here in Wisconsin, up to 20% of a person's disposable earnings may be garnished by the judgment creditor. Disposable earnings has a specific meaning, and that is the earnings that are left after one takes out state and federal income taxes, as well as Social Security and Medicare taxes. So that can be a significant amount of a person's paycheck. There are, however, very important exemptions and limits on the amount that can be garnished that reduce the harm to the debtor. For example, the debtor's earnings are completely exempt from garnishment if the debtor receives, or in the past has received, or is eligible for need-based public benefit programs. And there are many need-based public benefit programs here in Wisconsin. And so if a person who has a garnishment order or is in the garnishment process would meet the criteria about public benefits, they would need to let their employer know about that, and the person should be completely exempt from garnishment. The point here in the third bullet is that the debtor must claim these exemptions and limits. Again, going back to my theme of do something, take a step for yourself. If you let the process take hold and you don't respond, the result in the garnishment process will be that 20% of your disposable earnings will be withheld in order to pay on that judgment. Next slide, please. And so we're back. This slide should look familiar. I really encourage you to contact the Consumer Law Clinic. We have a new project where we are focusing on garnishment relief for people helping them understand and access the rights to which they are entitled to reduce the harm of a judgment that comes from a consumer debt. So I'm going to just pop over to the questions section on the screen and see if we have any. This is a very good question. It seems that debt collectors don't want to work with you when you're trying to resolve the account. How can you talk them down in the amount you owe per month? That's a very good question. And it depends on the facts of the case. If it's an amount that is a significant amount of money, I realize that they can be difficult to deal with and may not take the money that you can pay on that account. And so that's sort of making a decision about making a payment plan, a voluntary payment plan from money that comes out of your net earnings, and you are paying the other side that money every month. And frankly, if they are not willing to accept what you can pay that way, then they may have to garnish your wages, which you might be exempt from completely. So it might be a question of either they accept an amount that you can pay basically out of pocket per month, or they might receive nothing per month if you are exempt from garnishment, or if there are limits on the amount that they could garnish for out of your earnings. So sometimes that works. Frankly, even, I've dealt with creditors and attorneys who just won't budge, and they'll say that their client will not accept the amount that you are proposing. And if you've tried, then you've tried, and that's about all you can do. I pointed out the debts that come from consumer credit transactions because sometimes the other side, the other party, might be willing to negotiate about knocking off some interest so that the total amount that they are claiming, that they are seeking, is reduced. And then you could propose making monthly payments on that amount, especially for an old debt. The amount is just going and going and going up and up and up. And they might be in a position to say, well, our client would rather have something than nothing coming in at all on this account.
All right. Well, Sarah, thank you again for being here today and for providing such helpful information and resources. This was a wonderful presentation. So thank you all also for joining this Lawyers for Learners webinar, and we hope you have a great rest of your day.